We have a situation where there is some mixed opinion from a legal standpoint as to whether or not the supermajority vote is legal in view of the majority rule statute that was enacted, in my understanding, was enacted subsequent to these supermajority policy requirements. And therefore, there is a question legally, as this TSBA acknowledges in this policy insight, as to what is legally required at this time. I think that's pretty much what I have discussed with you all in the past couple of weeks with regard to this situation. So, as far as the board is concerned, they can do one of two things with regard to this situation. One, they can leave it as is, and presumably, I guess the word is hope, that it stands up if it is illegally challenged. And that would mean doing nothing and going proceeding with your elections. The second thing is, if you want to do what this policy insight has suggested you do in the spring 2012 insight, you would have to, number one, by majority vote, you would have to rescind the 2/3 rule for requiring a policy change, which you can do by majority vote, because that statute says you can act by majority vote. Yes, that's correct, by the way. The second thing, if you wish to do this, you don't have to do this. The second thing, if you do that, then you would further have to, by majority vote, change or amend this policy, as was recommended in this policy insight, to delete the 2/3 requirement, which automatically would revert back to the majority members rule per the statute.
Is the 2/3 policy legal?
It's questionable.
Can this board have a higher standard than state law?
That's the issue. There are no case laws on it. There's mixed legal opinion on it. There's this Tennessee TSBA policy insight, which in effect recommends going away with it, that was sent out spring 2012. No one can say for sure, but it is a issue.
I have a letter dated yesterday from Lawrence F. Giordano with the firm of Lewis, Thomason, King, Krieg, and Waldron.
I see.
In this letter, he clearly states that our policy is not illegal.
That's his opinion. He's entitled to it.
And he's with a firm that deals specifically in education, law, and policy issues all the time.
I wonder, I don't know, if Mr. Giordano has seen this policy insight. This is clearly stating that TSBA is recommending that you do away with it. That's what that says. So, Mr. Giordano's entitled to his opinion, I'm entitled to my opinion, other lawyers are entitled to their opinion one way or the other. But clearly, TSBA thinks it could be a problem. Well, they would not have sent this out.
After receiving your letter, David, I took it upon myself to get an opinion of a neutral firm. Number one, you can't have a super vote unless it is listed in your charter. That's for school boards, corporations, or what have you. Number two, there's no cases ever been tried due to a super vote. Gave you documents, and the third thing they said, you're best served to listen to your legal advisor, because in all probability, if you don't change your policy to reflect more of state law, you could stand a chance to open up the Pandora's box of a lawsuit. Wilson Worley Gamble and Staff.
Mr. Collins, can I address the board?
I entered into this director search process at the urging of the educational community. Before throwing my hat in the ring, I studied the school board's list of criteria for the qualities they were looking for in the next director. I felt like I was a good match. I want the best for our community, and I thought I had a chance to enhance the quality of all education for boys and girls in Hawkins County. I wholeheartedly sought this position, not out of personal ambition, although it would be a step up in my career, but I did because I thought I would be a good addition to our team that is currently in place. I believe in our school district, our administrators, principals, assistant principals, and especially our teachers. I realize any appointment requires making tough decisions, and I respect the board's challenge. After a lot of family discussion, prayer, and reflection, I've decided to withdraw my name from consideration as Director of Schools in Hawkins County. I appreciate the confidence that the majority of you have in me, and I wish you much success in filling the Director's position. I intend to continue serving our students and look forward to the upcoming school year. Thanks again.